fact that their country's TPS designations are extended. They are aware of the conditions in their country, and they've come to rely on the fact that they are not going to be made to return to their countries until those conditions have improved, and they have come to rely on the fact that that assessment is made looking at the conditions writ large and not in this narrow way.
Let me ask you, you raised that point, aren't those expectation interests as opposed to reliance interests? Usually reliance interests is a change in position and reliance on something you've done that you would not have done otherwise, and I'm not sure what that would be here. I mean, people may expect that they were going to be able to stay here longer, but it is a temporary, nobody was promised a permanent status here. So I'm not sure what, there's no example in the complaint of what people have done in reliance that they would not have done had they known. It's really an expectation interest that is based on an expectation there'd be, certain rules would apply before the TPS status would be terminated.
It's a reliance interest, Your Honor, in that, and the example that we give in the complaint that I think is most goes to this question is that plaintiff Huwaida Alarbi, for example, she's held TPS for 20 years. In 2015, she made a decision to invest in a restaurant. She made a decision to start her own business. When the TPS termination was announced, she sold that business because of the uncertainty, and she sold it at a loss. So people are making decisions about their lives that are different from the decisions they might make if they thought they would have to return to their countries before conditions in their country had actually significantly improved. Another example, Your Honor, is we have several plaintiffs who are, college students. We have plaintiff Maria Jose Ayala Flores has decided to study math in college because she wants to be a math teacher. If she thought that she was going to have to return to her country, she might make a different decision about what to study. So we do think they are reliance interests and not just expectation interests, Your Honor.
What would be the reliance interest there? You mean studying a different subject or not going to college, or what? I'm not sure I understand.
I think the choices that are made, yeah, it could be to not go to college and to instead get a degree in whatever job is most in need in the other country. Decisions are being made with the assumption that people are able to stay and won't have to return to their countries until conditions have improved. And I do think people would make different decisions about what to study, about whether to go to college, about what job to take, about what business to invest in.
I guess the hard thing about that, I mean, I understand what you're saying. I think the hard part about that is that it's not like, you're guaranteed to stay here 10 years, now we're shortening it to 5 years. It's always, it's 6 months, 6 months, 12 months, 12 months, maybe 18 months. And it's subject to periodic review, and it is, and especially given the lack of judicial review on the merits, it's not so much based on, objective conditions on the ground by itself, but the Secretary's assessment of that, which is largely unreviewable under this statute. So the reliance interests seem to be tempered to some extent.
In a practical way, the reliance interest is the assumption that the Secretary, maybe the decision is non-reviewable, but that it will be made in a non-arbitrary way, and that there won't be this sudden change when, from the plaintiff's awareness of what's going on in their country, nothing has really changed, but the decision that comes out is completely different and is not in line with the decisions that have been made for the previous 20 years.
All right. Let's talk about the discovery issues. I know some of this is sort of conditional on what this court decides on the merits. But if we assume for the moment that I find that the jurisdictional stripping provision of 1254A does not preclude either the constitutional claims or the challenge to the procedural, broader, systemic change in criteria that the plaintiff allows, that determination is to be narrowly construed to mean the individual country-by-country determination, which is fact-based, and that at least there's an APA claim that's been stated once we get past the jurisdictional issue, and at least as alleged, an equal protection claim. I'm less certain about the due process claims, but assuming there is a constitutional claim and an APA claim that goes forward, what do we do about discovery? And how does this fit into a larger time frame in terms of what is happening? Because we have to look forward in terms of what the sequence of events are. I guess the first